Hey everybody, this week's episode features a compilation of some interesting legal scenarios. Please remember none of this is legal advice, every situation is different. Enjoy.
Yeah, so people think that they can arbitrarily just evict someone. What you need to realize is that there is a process. This is Canada. There is a legal system in place. So if you want to evict, and the most common way would be for non payment of rent, you can't just walk up to them and say, I want you to leave, or else I'm going to call the police. Police have nothing to do with this. If you call the police and tell them that you have a tenant not paying rent, they will tell you this is out of our jurisdiction. You need to go through the landlord and tenant board. To go through the landlord and tenant board, you now have to give a notice to the tenant, file an application to get to the board. You're looking probably at, I'm going to be a little dramatic, but let's say 6 to 8 months to get to the board, another 30 to 60 days to get the order, and then 3 to 6 weeks, depending where you are in the city, to actually have the sheriff come out. So I want to say there's only three ways to evict a tenant. Number one is when they give you notice, which is usually the N9. Number two is going to be a mutual agreement, which is the N11. And number three is the court order. The N9 and the N11, you can file for an ex parte order for the eviction. But most of the people watching here, if they are doing it for non payment of rent, you have to wait for the court system, and then the sheriff is the one that does the eviction. The sheriff is the court appointed officer for the court. They are not police. I want to make that very clear, okay?
So let's just start with this. Let's say I'm a landlord. I have a property, a little condo that I rent out to Susan, and Susan passes away. As a landlord, what do I have to do, need to do? What happens? What's the process?
Right. So, in that unfortunate situation, this is governed by Section 91 of the Residential Tenancies Act. And what that says is that the tenancy is automatically terminated after 30 days. So, the landlord has certain responsibilities that they must fulfill within that 30-day period. Once they discover that the tenant has passed away, the landlord is going to want to make sure that they contact, well, first of all, the police if they're the ones who discover the body, so that the police can contact the next of kin of the deceased. If somebody else reaches out to the landlord and lets them know that their family member has passed away, then the landlord should secure the property because they're responsible for everything that's in the property. And the most important thing first is what to do with the body and must be treated with respect. So the next of kin will be responsible for disposing of the body and making the appropriate arrangements for that. If there is no next of kin that's located, then the police will deal with the body. Okay. Now, the landlord is responsible for making sure that the owner's property, the tenant's property, remains safe and secure. So there's an exception where they have to dispose of anything that's unsafe or unhygienic immediately. Otherwise, they must provide reasonable access to whoever is responsible for administering the estate to deal with that property, to remove it. And they need to ensure that the person who's coming into the rental unit is, has the appropriate authority. So they can prove that in a couple of ways. One, if there's a will that says that they're the executor, then they have the appropriate authority. If there is no will, then you're going to want to make sure that they, you need to know what their relationship is. Okay. So you're going to want to verify their ID, and you're going to want to make sure that within the 30-day period, any property that will have to go to the estate has been accounted for.
sadly, it's something that people are always curious about. Hopefully they never get into the situation where they have to get to this, but it is inevitable that landlords do have to collect rents, whether it was eviction of non-payment or utilities that didn't get paid or whatever a landlord is owed monies for after tenancy has been terminated. So yeah, what do we do once we have that order from the LTB?
In these kinds of landlord and tenant board orders that set out the money owed, it sets out how much was awarded based on the application, plus the application fee, plus the interest that accrues on the non-payment of the order. Okay, so the landlord and tenant board actually doesn't have the jurisdiction to enforce monetary orders. They can do everything else like evictions, okay, but the jurisdiction of collecting on monetary orders falls under the small claims court. Okay, and that's why the highest amount that a landlord could collect from a tenant is $35,000, because that's the jurisdictional limit of the small claims court. So hopefully no landlords are in a position where the tenant owes them over $35,000, because they're not going to get an enforceable order for anything above that amount. All right, so getting the order at the landlord and tenant board is the first part. It's the easy part. Now the heavy lifting begins. All right. So the first thing that you want to do once you get the landlord and tenant board order is to file it at the small claims court with a small claims court form called the certificate of judgment. All right. That puts in all the financial information from the landlord and tenant board order, and then they give you a judgment back with a small claims court file number and the very important small claims court seal on it. So now you can take that small claims court order and enforce it. So the small claims court offers 4 enforcement options. The first is garnishment. The second is writ of seizure and sale of personal property. The third is writ of seizure and sale of land. And the fourth is writ of delivery. Now, practically, the only one that landlords would use is garnishment. So I'm just going to focus on that. So what is garnishment? Well, that means that you serve somebody with a notice of garnishment who owes the debtor money, okay? And in this case, the debtor is the tenant who owes you money. They become the judgment debtor. So the most often are people who are the employer or the bank. Those are the 2 most common people who owe the debtor money. So you can garnish from them. So to complete the process, you just have to fill in a couple of forms, the affidavit of enforcement request and the notice of garnishment, and then file them at court. And once they're approved, then you have to serve them on the employer with the garnishee's statement return. Okay. When you do that, the bank, let's say you serve it on the bank, they will pay the money into court, and the court will hold it for 30 days and then pay it out to anybody who has registered a garnishment at the court, just like you did.
We have on our leases, it says no pets, but now we were told or noticed that our tenants have a little puppy or a little cat. How does that work? What can we do?
So here's the thing is that no pets is actually goes against the legislation. So you can put it in your contract. The question is that if they bring in a pet, what can you do? Can you evict them? The answer is no. Okay. Assuming that this is not a dangerous pet. So it's not like a snake or like some kind of venomous pet that it's a legal pet, I guess you can say. The only caveat to that would be is that, let's say, for example, you're renting a house and there's a basement and you have allergies and you've told the tenant, look, the reason why I'm asking for no pets is because my child or myself have allergies towards dogs, cats, whatever the case is, and I'm requesting that there's no pets allowed, even though it goes against the legislation. This is something that would be able to be argued in a board because of if you have a medical condition. And that also goes with smoking, by the way. So a lot of times, if you're sharing like a basement and a main floor and there's an allergy to cigarettes or whatever the case is, As long as you can show that, you can fight that in the board. Okay. Other than that, you can ask if they have pets in the beginning, but if they bring pets in afterwards, the only time that it would be effective would be in a condo is if it goes beyond the weight limits of the guidelines. So usually for a condominium, I believe it's 25 pounds, if I'm not mistaken, which is like a small dog.
Every condo is different compared to their condo board. I've seen some that say no dogs. I've seen some that say they have a weight limit, whether that's 25 pounds, 50 pounds. Some say no more than one dog, or anything like that. So anyways, that is definitely specific per condo and their condominium board rules. But like you said, if you were renting out a basement, would that only matter if you were upstairs? What if you had a fourplex, for example, and one of your tenants was allergic to dogs, and now someone got a dog? Same thing would apply there.
I'm going to say no, only because that tenant can change. So you can try to fight it in the board, but again, it does go against the legislation.
They believe the tenant on the lease has left their unit, but left behind her pregnant, underage granddaughter of 16 and the granddaughter's boyfriend of 15. The rent is still getting paid, and I see the lady every once in a while, 1 or 2 times a month, come in to check on them. The unit, though, has been destroyed. There's holes in the walls. There's dog faces everywhere up against glass. They've been smoking in units, breaking windows, unplugging all the smoke alarms. So now there's an issue of hazard that way as well. And supposedly they're causing problems with other tenants in the building. What is this landlord to do? What are her options? Obviously, with safety issues, other tenants, and then again, just this one unit as well.
Okay, so this is not abandonment, just so you know. And the first thing that I'm going to say is occupancy has nothing to do with tenancy. So you said something important. You said that the rent is still being paid, even though the person on the lease is not living there. You said, I believe the niece is living there. Is that correct?
It was a granddaughter, but yeah, same thing. Someone who wasn't originally on the lease is now staying there.
Okay, so those people that are staying there are considered occupants, guests. So I don't see anything illegal or wrong here from what you're telling me. For abandonment, there's a two-part test that you need to consider. Number one, are there belongings there? And number two, is the rent being paid? So in this situation here, even though the tenant is not residing there, the rent is still being paid and there is someone occupying the property. So in regards to what the landlord can do, your options are quite limited. If they're making a disturbance in the property, you can give a notice for disturbing the other people there. However, just remember, to get to the board these days, you're looking at 4 to 6 months and then 2 months to get the order. So I'm not sure if that's going to be a plausible option, but this is not abandonment. Abandonment would be something separate.
Please remember, while we are professionals, this podcast is for informational and entertainment purposes only. The advice shared may not apply to your unique situation. Always seek personalized advice from a qualified professional before making any investment decisions.
Hey, everybody. Thanks so much for joining us this week. I hope you enjoyed the episode. If you're finding it informative and useful, make sure to like, subscribe, share with a friend so that we can keep getting the information out there to Ontario landlords. And keep on joining us. We'll see you next time.